All right, so we're there on 3, the requirements for a license. Remember, if you remember back license law, one of the things it talked about was license law determines what activities need a license. So in Indiana, and I've practiced this and I can't say it slow, buy, sell, trade, lease, exchange, manage, list, rent, consult, and refer. All right? Buy, sell, trade, lease, exchange, manage, consult, or refer real estate, you need a license. All right? Now, like everything else, letter C at the top of the next one, there are exceptions to who needs a license. So let's go over some of these exceptions. The first one and most notable is number 1 is the FSBO, for sale by owner. Remember, disposition is one of your rights. You have the right to get rid of the property as you see fit. If it's your property and you want to sell it, you don't need an agent. You want to buy it for yourself, you don't need an agent. That is not a license required. Only if I want to sell it for someone else, which is called brokering, do I need a license. All right? Number 2, any attorneys practicing law. If an attorney is practicing law, they don't need a license either. That is part of their daily activities. Indiana says if you're a practicing attorney, you don't need a license. The Bar Association really likes them to have either a business or real estate attorney. You know, we're kind of more liberal. We just say any attorney practicing. Because remember, you also got family attorneys, mergers and acquisitions. But the reality is, our commission says if you're a licensed attorney and you're practicing, you don't need a real estate license. Now, the funny thing is I know like Jeff Jinks used to be a partner with me. He is a licensed attorney and a licensed broker. And then you've got somebody like Bob Nice, who practices real estate, who does not have a license, but is a practicing attorney. So even in the attorney world, they argue back and forth whether they need one. Public officials carrying out the law. Sheriff's sale. The sheriff does not have a real estate license. He is conferred the power by Indiana state law that says he sells houses. Legal representatives assigned by the court is basically the easiest. A trustee, the executor for an estate, a receiver, anybody the court appoints to sell property doesn't need a real estate license. The easy way to remember this is if a court appoints them, they are working as if they were that person. And that person doesn't require a license for sale by owner, right? So an executor selling an estate would be acting as the owner of that property. Therefore, the owner's exempt, so are they. That's the way to remember that. Any rentals less than 30 days. You guys know those extended stay hotels? How long can you stay? 30 days. Now, you can stay as many 30 days as you want, but you can't sign a lease for more than 30 days, because if you did, that would require the person behind the counter to have a license. All right? Because if you think about it, overnight hotel is leasing property. But because it's only one day, it's exempt, so the person behind the counter doesn't have to have a license. That's the loophole for those extended stay. You sign a 30-day, at the end of the 30-day, you go downstairs, sign another one. And you could do that virtually forever. You just can't sign a 60-day with them, because that would require a license. All right, number 6 is what I call the Carl Van Roy rule. Anybody know Van Roy? Property management downtown. They manage like 6,000 units. He's licensed. Anybody that is employed by him can also do license required activities. They are employed and supervised by a licensed broker. All right? Because he's licensed. 6, now I'm going to jump to 9 because 9 is very similar. Regular full-time salaried employees of the property owners. This is what I call the Simon rule. Simon, people that work for Simon that rent out Macy's and all that in the mall aren't licensed either because they're employed by the owner of the mall. And the owner is exempt for sale by owner, number 1 rule. So you've got 2 rules that are slightly similar, but make sure you understand. Carl can manage properties and do stuff because he's licensed, and people that are employed by him, under him, can do the same thing because he's licensed for third-party people. Simon, people that are employed by Simon can rent out his properties because he's the owner of the property, the Simon Real Estate Investment Trust. So using that same analogy, anybody in here have rental property? You got a rental property? You employ, that's the key word, not 1099 contractor. You have to employ, if you employ a maintenance man, he can show your property for you because he's employed by the owner of the property. Okay? So that's 6 and 9. 7 is a stupid law. Apartment rental, 12 units or less, owned and managed by the individual, or 12 units are on one or adjoining parcels. Well, first of all, if they're owned by the owner, he's exempt right out of the gate. Cross-state referrals. This is how we get referral fees if we send somebody to Florida, and that referral can come from Florida across the state because I'm licensed in this state. We do the same thing. It's called reciprocity. We can pay other brokers in other states for referrals as long as they're licensed in that state. Public auctioneers, number 10. They cannot broker. Don't confuse these 2 activities. The auctioneer can stand in the front yard and say, give me 5, give me 10, give me 20, give me 30, and sell the house. What he can't do is put a sign in the yard and say, hey, if you want to see it before tomorrow's auction, come see me and I'll show you the house. We'll take an offer on it. No, that's brokering. That's what we do. Conversely, just like that, you can't stand in the front yard and go, give me 5, give me 10, give me 20, because that's auctioneering and that's a separate license and you don't have it. Unless you do have it, and that's a whole different story. There are a lot of auctioneers that have their real estate broker's license just for this thing because they do that a lot. They will get an estate and they will list the estate on MyBor before the auction, and if they get an offer, they'll sell the estate before the auction. What's his name that used to own the Mascari? Tom Mascari, good example. Auctioneer, licensed broker. Who? Christie's, are they licensed? Okay, I don't know that for a fact, but it makes sense for a lot of the auctioneers to do that. All right. 11's my favorite one. The sale, transfer, or lease of cemetery lots does not need a license. The word that bothers me here, lease. Oh boy. You, out. That's where the Walking Dead come from, I guess. They got evicted. 12, acts by out-of-state commercial brokers regarding commercial real estate and properties affiliated with a managing broker here. This is what allows those big commercial companies that are like Cushman and Wakefield to come in and do subsidiaries like Acorn, which is a small local company, but it's a subsidiary of Cushman and Wakefield so that they can take their investors out of state and stuff like that. 13 is the one I think they should have, oh wait, that's 14. 13, an out-of-state licensee, as long as they're licensed in that state, we can pay them referrals. But 14 is the one I think they should have led with, or anything else that the commission says you can do. So virtually, if you got something other than this, and the commission says sure, then you're good to go. Property management does require licensed required activity. Unless you're employed by another licensed guy, then they don't need it to be. Appraisals are licensed separately. It is one of the other groups under the PLA. Broker price opinion, remember we are allowed to do appraisals as long as we follow the USPAP, the Uniform Standard of Professional Appraisal Practice that the appraiser would. It is still a license required activity. Letter G has got some definitions that you all ought to be very aware of already. The principal is the client. A licensee is anybody that has a license. The agent is the one that has the relationship with the client. There's a whole 17 of these that we've talked about. Broker. Number 5, salesperson. It was eliminated. We do not use the term salesperson in Indiana anymore. Number 6 is a principal broker. We don't use that term either. Now they are all called number 7, which is a managing broker. It is the one with whom the commission holds responsible for the action. All your actions, if you are my agents, I am liable for as the managing broker. A branch manager would be someone who is managing one of the offices other than our main one. For instance, Jennifer Weberg is one of my managers. She's a broker. I'm the managing broker, but she is the branch manager for the Franklin office. All right? She's still a broker. A broker company, obviously that is the brokerage firm, i.e. the Modulin Group, or Tucker. That would be the brokerage company. An individual broker is a person who is put in charge by the corporation. Remember I told you that really the managing broker is Real Estate Monkey LLC, and they named me to be their acting human body. I'm the individual broker for that. An affiliated licensee would be anybody that is under me. You are all my affiliated licensees. Responsible party we don't use anymore. The listing broker deals with the seller. The selling broker deals with whom? The buyer. Limited agent represents both the buyer and the seller on the same deal. In-house is when there are 2 agents within the same brokerage company that represent each side of the deal. One is the listing side, the other is the selling side. And then they define commercial real estate as any parcel that is not 1 to 4 units. Any questions about who those? You guys should have heard all of those by now. Let's change audio.